Good morning. A very warm welcome to you all on behalf of Advocates for International Development, or A4ID. How are you all this morning? Well? Yes? Lots of nods around the table, lots of smiles. That's nice to see. I hope that those of you who joined us last night had a great evening with us. It's good to see who are now familiar faces, so that's great. And we're looking forward to working with you throughout the day on this programme on business and human rights.
In relation to this leak, but has always said that legally it is not responsible because the actions and any fault that might have occurred in relation to the operations in the factory were the responsibility of the local Indian company. Nevertheless, there's been litigation against both companies over the years, and there's been settlements which haven't produced very large amounts for the victims involved. There's even been successful criminal investigations and prosecutions in 2010 of the people who ran the Indian entity, which has subsequently gone bust. But nothing very sort of comprehensive. In 2001, Dow Chemical purchased Union Carbide Corporation, the American corporation. they have said from the outset that they bear no legal responsibility for the problems that occurred prior to the purchase of the company. However, there remain outstanding requests, continuing requests for Dow Chemical to do something about the situation there, because there's still clean-up operations that are outstanding, and because nobody has taken responsibility, the situation on the ground remains hazardous for people, and yet nobody has addressed those. So what we have in this example is a situation where effectively there's a gap in accountability, because the Indian company which went bust, there is no redress against that company for monetary compensation. There was criminal accountability, but in fact the sentences were very light. And with criminal accountability of that kind, what we're missing really in that picture is any remedy for the people that are continuing to have health problems because of the ongoing gas leak. But what we also have is, from the flip side, we look at this, the impact of this from Dow Chemical's point of view. We have ongoing pressure on Dow Chemical to do something about the situation, and ongoing reputational damage to the company that it is involved in this situation, notwithstanding that it considers that it doesn't have any legal responsibility. So, by way of example, in 2012, the International Olympic Committee chose Dow Chemical as one of the sponsors for the London Olympics, and this caused a great outcry, resulting in the London Mayoral Committee itself actually complaining about the fact that Dow Chemical was supporting the Olympics, and the reputational impact that an association with a company such as Dow Chemical, associated with impacts such as these, would have. And the story's not over. So even as recently as May 2016, Amnesty International has been very active in now lobbying the American Department of Justice in saying to them, you need to stop creating barriers that prevent victims accessing Dow Chemical to have redress for these issues. And at the moment those are being blocked and they're not very successful, but you can see how, from Dow Chemical's point of view, this is continuing very, very live issue for them, very, very late in the day. And against the whole of this background, we still have continuing problems locally. So that is perhaps quite an extreme example of the way in which business activities have human rights impacts. And there are countless other examples where perhaps the impacts are less obviously severe. So just picking a few, we might talk about labour issues in relation to migrant workers in recent international sporting events that have been in the news. Or we might talk about water issues in relation to soft drinks manufacturers, where there are questions there about the amount of water that's being used for the product. Or we might talk about oil and gas projects or mining projects where a company might have to employ private security because the licenses in a production the production licenses in an area of conflict, and that will also often produce problems with the right to life. So before I get into the guts of the UNGP, I just wanted to take a moment to explain some of the background to their genesis. Back in 2005, Professor John Ruggie was appointed as a special rapporteur on the issue of business and human rights. And at that time, there were two main agendas in the international space around the interaction between these two issues. On the one hand, there was a document called the Norms on the Responsibilities of Transnational Corporations and Other Entities on Human Rights. That was tabled in 2003 by a group of human rights experts, but it never went anywhere. And the reason it never went anywhere was because what it proposed was that companies should have binding obligations in international law for those human rights that fell within their sphere of influence. Those of you who studied it, who practice and study international law, will know that this was a very radical reshaping of what international law means, where the traditional obligors in that landscape are the states, and the corporates are like persons, are like the subjects of rights and have no obligations. So the suggestion of binding obligations on corporates was roundly rejected as being unattractive and unrealistic. Simultaneously, what we had was the development of a corporate social responsibility movement, which was entirely voluntary. It was spearheaded, I think one of the best examples of this was the UN Global Compact that came into, which you'll be very familiar with, which came into being in 2000. It was a very bold act. We had the UN Secretary General for the first time of actually focusing on business impacts, and it was very significant. And over 10,000 companies signed up to this, and within that also agreed to respect human rights. But the problem with it was that it attracted criticism because it lacked an enforcement mechanism. And the only real issue if you fail to respect human rights in that context is that you get delisted from the compact. So at that time there was a kind of a loggerheads between voluntarism, which suffered from the lack of enforcement, and the push for mandatory obligations on companies, which was just completely undesirable and untenable from a theoretical point of view at that time. So Ruggie was brought in against this background to really spend some time actually mapping out what the relationship between business and human rights looked like. And it's very important to remember that what he did was produce a lot of reports, worked with a lot of lawyers, businesses, NGOs and other stakeholders, and victims as well, victims of human rights abuses, to build voluminous amounts of empirical data about what was actually happening. How is business actually regulated? What are albeit that they're not described as human rights, how are human rights types issues being regulated by states, and how are companies responding to those? Out of that, he proposed a three-pillar framework with which you will be familiar with. The first pillar is that states have, and it was evident from his empirical research, the duty to protect human rights, and that duty extends to preventing human rights abuses by third parties, such as businesses. Secondly, businesses have a responsibility to respect human rights. And thirdly, when impacts do occur, victims have a right to access a remedy. Now, this framework avoided controversy because what it purported to do was nothing more than map out what the existing obligations or the perceptions of the role of business in the community was, and it was based on evidence. So it actually had huge support from the corporate community at the time. And what he was basically proposing within this framework was what we have in terms of the governance of corporations is a mix of measures. We don't just have one instrument that says that corporates are obliged to respect human rights. We have public law, we have civil law, we have criminal law, we have voluntary measures. We have all of this as a smart mix of measures. Now, the UNGP are an extension of that framework, and essentially, as you know, they comprise of 31 principles that outline each of, or put the flesh on the bones of each of the pillars that I've just described. So we'll start with the first pillar, the state duty to protect. So, as I've already mentioned, in respect to the state duty, we already know that international human rights requires states to protect, respect and fulfil human rights, and that extends to third parties. And the UNGPs restate this. They don't do anything more than that. And what they do is they articulate that the state must comply with this standard of conduct. It's not necessarily liable for the actions of the corporate, in any situation, but what it could be liable is for failing to adequately legislate and adjudicate and enforce the legislation that is put in place in respect of those companies. So the contribution of the UNGPs in respect of the first pillar is really to set out some practical steps or to flesh that out in a practical way. So the first thing they say is that, bearing in mind this responsibility, states need to have a coherent policy internally for dealing with human rights. And this is in recognition of the fact that, as we know, within governments there can be often different players. You might have a human rights department on one hand, and you might have an export credit agency on the other hand, or an investment arm on the other hand, and very often there's a lot of tension between those two between those two organs of the government themselves, which can make it very difficult from the outside to know what the government's policy is. The UNGP say that states should set out very clearly what their expectations of business enterprises are, and they actually say that expectations should be set out in respect of the business's operations in the jurisdiction of the state, but also throughout their operations. And this is fairly significant, because obviously when you've got a home state that's saying, I want a corporation to act respectfully, respect human rights in this country, that's one thing. But as soon as you start talking about and everywhere you operate, that has very international consequences. The UNGP also say that the state should have adequate oversight of its human rights obligations when it's contracting with business. And again, this is very important. This is key to procurement, for example, and really what the states are being asked to do under this pillar is to be mindful at all times in their commercial transactions with business that they also have human rights obligations which need to be fulfilled and respected. So what they need to be doing is they need to be ensuring that there's enough policy space for them to respect their human rights obligations and not constricting themselves unduly through the terms of their contracts or their procurement processes, or even through their treaty obligations. And most notably this has been seen in the field of investment treaty arbitration, where there's typically been a lot of criticism that states have favoured investment rights of businesses over the ability to legislate properly for human rights within their jurisdiction. Cannot be expected themselves. I mean, they are often committing human rights abuses, but they cannot be expected in that context to be supporting human rights. In that situation, what the UNGP say is that it is incumbent on the home state, so where the investor has come from, to make sure that their companies are operating in a way that's respectful of human rights in that context. So, over the last 5 years, since 2011 when the UNGP were brought in, we've seen a range of responses from governments. And broadly speaking, we've seen some who've been very proactive in embracing the heightened state duty to protect, especially, for example, in Norway and the Netherlands and Sweden. They're perhaps notable examples. But we've also seen a slight mistrust of this whole area, and this touches on a point that I was just talking to somebody on my table about earlier. There are some states who are saying, well, this is all very well, but really you shouldn't be looking to us as states to do more. We still think that more should be done in respect of obligations on corporates. And this has been expressed in a movement to call for a treaty on human rights, which some of you may have heard about, which basically says, no, let's go back to the drawing board and think about corporations, binding obligations on corporations at the international level. That said, on the whole, even in those states who have signed up to this resolution requiring a treaty, of which actually, in fact, Kenya was one, we are actually seeing considerable progress and adoption of the UNGP. So how are we seeing this? At a very basic level, we've seen at a very international level, we've seen a lot of guidance. So we've seen multilateral organisations such as the OECD provide guidance for sectors like the oil and gas industry, the manufacturing industry, on how to apply the UN Guiding Principles. We've seen international standards that are drawn up by multilaterals, so notably the IFC, align their standards with the UNGP. So the 2012 edition of the IFC standards are said to be compliant with the UNGP. And we've also seen some developments, particularly in Europe, with entities like the Council of Europe, which is responsible for the European Convention on Human Rights, and the EU driving the UNGP and the need to uphold the UNGP in member states. At a national level, we've seen two developments. Firstly, policy developments, and secondly, legislative developments. On the policy side, we've seen the development of national action plans, as you will all be aware of in this room. Now, these national action plans you could view as just being policy instruments that don't really mean anything, but actually they've got some very important and significant implications for business. They create in and of themselves momentum in this area because states are really they're really using these documents to create leadership on these issues and to create clarity and expectations for companies in terms of what they can expect in the future in terms of legislation that will bring the UNGP into hard law. They also clarify what states are already doing, and it was quite interesting because I think, having reviewed all of the national action plans that are out there, at the moment there's about 9 or 10 published national action plans, but there are many more in the pipeline. They're actually doing more than one would have anticipated. So for example, ECAs in a number of countries, in particular in the Netherlands, are imposing specific obligations for companies to respect human rights before they will be able to receive funding for their international investments. And in a way, the National Action Plan's been as useful a tool as any for highlighting those to the companies in those regions. But in a way, I suppose the most important contribution of the National Action Plans is in foreshadowing the legislation that will be coming. And in terms of legislation, I think so far in the last 5 years, what we're really seeing is a focus on requiring companies to report on human rights and other non-financial risks. This is something that has been in train for a while. So we've had things like the Dodd-Frank Act in America that focuses on supply chains in relation to conflict minerals, so tantalum, gold and tungsten. But what we're really seeing is more and more of these types of provisions. So since the UNGP came out, we saw the US requiring its certain companies above a certain annual turnover threshold to report on corruption and human rights abuses if they were investing in Burma. We've seen in Europe, we've seen a strong drive around non-financial reporting by way of a directive, which all member states will have to implement by 2017, where they'll be required to ensure that certain large public interest entities, and that term will be left for definition by each member state as they implement the directive, to report on both human rights issues and also environmental issues. We've also seen certain countries take more specific steps in terms of their legislation. So in the UK, for example, in 2013, we had an amendment to our Companies Act, which now requires a strategic report, which is a report that must be issued by the directors that needs to cover both environmental, again, and human rights issues. And most recently we've had the Modern Slavery Act in the UK, which is again a reporting requirement on companies to feed back and make transparent any issues that they, or the steps that they're taking in relation to potential issues of human slavery in their businesses and supply chains. But we'll come back to that in a bit more detail later. So I want to move on now to the responsibility to respect. And really this is the most innovative part of the UN Guiding Principles. So this is set out in Guiding Principle 11. It says that business enterprises should respect human rights, and what this means is that they should avoid infringing on human rights, and they should address adverse human rights impacts with which they are involved. The important thing to note here is that it's not simply a do no harm standard, that's in there, but it also requires that the business goes on and takes action to mitigate the problems as and when they do occur. The responsibility to respect under the UNGP has a number of sort of salient characteristics which I think is really important to understand, and which takes us quite a lot further than the responsibility to respect as was reflected in the Global Compact that I mentioned earlier, mainly because it's very specific. The UNGP say that the responsibility to respect applies to all internationally recognised human rights. So you don't pick and choose, you don't say, well, business is typically only involved in economic issues or social issues, and therefore it should only be responsible for those issues. It says, no, actually, in theory, businesses can affect every human right that's internationally recognised, and so we shouldn't exclude anything at the outset when considering what businesses' responsibility is in this area. At a minimum, this includes the Bill of Rights, and it also includes, as set out in the UNGP, the ILO's Declaration on Fundamental Rights, and also the 8 core conventions of the ILO. Secondly, it's not a legal obligation, as we've discussed. It's not in and of itself binding under this soft law instrument, but neither is it optional or voluntary. We sometimes get questions from clients sort of saying, well, you know, I heard about these UN Guiding Principles, but you know, can you advise us on whether we should sign up to them or not? And it's, well, there's no process of signing up to the UN Guiding Principles, they just apply. The reason why they just apply is because what's really at the core of the responsibility to respect is the idea of the license to operate that every company has. And essentially this is the acceptance or otherwise that the company has from all of its stakeholders in the society that it's working in to carry on its operations. And this is a very important concept that runs all the way through the UNGP, and it tackles this idea that they are not binding per se. And it really deals with the fact that regardless of whether or not there are legal obligations on companies to respect human rights, they will be judged. And the Dow Chemical example earlier was a very good example of this. They will be judged, and they will be criticised, and they will be held to account whether or not there's a legal basis for that. This is increasingly it's increasingly realised to be a very real issue for companies. There's a report, a group called Reputation Dividend, that tries to measure how important reputation is for companies. And in their most recent report in 2016, they identified that their top 10 companies that they analysed, each of them, it was valued that 40% of their market capitalisation came down to reputation. And of the number 1 company in their group, in that survey, Unilever, the figure was even higher, it was at 58%. So this really tells you how much reputation means in monetary terms to these companies. The responsibility to respect applies to all enterprises, whether large or small, whether transnational or merely domestic. And the reason for this is that really the capacity for a very small company to have a very large impact on human rights is very real. You think about a junior mining company that's entering a conflict zone at a very early stage of the development and production of oil, and then who will typically be in the region for a very short amount of time. The likelihood of them coming across and having to deal with very serious human rights risks is very high, and actually maybe much more than some other multinational companies which are much larger. And it also applies regardless of the legal structure. So whether you're a partnership, whether you're, however your corporate group is organised, it's still applicable. Importantly, this responsibility respect applies above and beyond compliance with the national laws of the country in which you operate. And this is pretty essential because this is really how you bring in the international law aspects to the responsibility to respect. Obviously, all corporations have to comply with national law, but if you are acting consistently with your responsibility to respect, you will also be doing so consistently with international law standards, which may well be higher than the national laws in place. So I think it would be useful now just to drill down a little bit on a couple of key concepts within the responsibility to respect, which are of particular relevance, I think, to lawyers when they're trying to tackle the UNGP and think, well, how am I supposed to actually advise clients on how to use this in their business? The responsibility to respect, as set out in the UNGP, comprises of three main elements. The first is that companies should adopt a human rights policy and flow that through their business. The second is that they should conduct human rights due diligence. That's got a very specific meaning, which I'll come on to later. And the third is that they should remedy the impacts that they have caused and contributed to, if appropriate. And I want to spend a bit more time thinking about this concept of responsibility. Now, I think it's important to recognise at the outset that this is not supposed to be a legal concept. And this is quite hard, I think, for lawyers to get their head around, because we deal all the time with causal links and understanding the relationship between actions and liability through the lens of responsibility. But this is, in a sense, is a wider concept. The UNGP envisage a spectrum of responsibility. They say, firstly, it's possible for a business enterprise to cause or contribute to an adverse human rights impact, and in that sense they have direct responsibility for the impact. Secondly, a business enterprise might contribute to the impact, but might not actually be you might be a retailer in the garment industry, and you might find out that a subcontractor in the supply chain has been using child labour. But you expressly told your contractor, the first supplier in the chain, not to use child labour. And you've done that by requiring them to sign up to supply codes of conduct. But in any event, you find out that this issue's occurred further down the supply chain, maybe at the second or the third tier through a subcontractor. Now, outside these three types of responsibility, having caused the human rights impact, having contributed to the human rights impact, or just being directly linked to the human rights impact, if none of these apply, then the business doesn't have a responsibility under the UNGP. And it's very important to analyse the responsibility quite carefully, because what the UNGP go on to do is to explain what businesses should do if one of these types of responsibility arises. And what they say is, if you've caused an adverse human rights impact, then you should stop causing it. Sounds quite simple. In fact, that can lead to quite a lot of difficult questions. I mean, one of the most difficult questions that we've seen companies have to deal with is, well, that's all very well, but you're telling us that we're we're causing this human rights impact in this particular country, say, that we've invested in. If we pull out, is that really stopping the human rights abuse, or is that actually going to cause greater human rights abuse? So there's more subtlety in that than might immediately meet the eye. The second course of action, if you have contributed to a adverse human rights impact, is you stop the part of contribution that you can control, and then you take steps to exercise your leverage over the other actors that are responsible for the human rights impact. If you're just directly linked to a human rights impact, self-evidently there's nothing that you can stop doing to remedy the situation. In that situation, what the UNGP says, the action you should be taking really revolves around this idea of leverage, and that's really what your action is. You should think about your leverage and how that can reduce the impact being caused. And I wanted to take a moment here just to talk about leverage in a bit more detail. I mean, I think we all have a very sort of everyday notion of what leverage means, but under the UNGP, I think it has quite a specific meaning, or at least it's worth thinking about it a bit more closely. So, broadly speaking, leverage is the ability to effect change in the wrongful practices of another entity, in this case. And the UNGP are helpful in the sense that they break that down for businesses and tell them that we should be focusing on who you have leverage over, what you have leverage over, and when you have leverage. So the who, in a situation where you might be contributing to an adverse human rights impact, that could well be the other business enterprise that is causing the problem, or it could be the state that has imposed an unhelpful law that means that human rights are being impacted, perhaps unintentionally. But it could be wider than that. It could be that actually who you need to be speaking to, or you need to be thinking about, is another organisation or an industry organisation who can perhaps bring to bear their leverage over the other entity that's causing the problem. As to what leverage is, this will very much depend on what your relationship is. I mean, this is where you get into the realm of thinking about contractual provisions. So if you have a supplier contract with them, or a joint venture agreement with them, what provisions can you be putting in those documents that mean that their behaviour will change in the future? Are you going to be putting in monitoring rights to say, well, I want to know more about what you're doing in your supply chain so that these issues are flushed out and so that we can deal with them more helpfully? Or is it going to be a slightly softer type of leverage, just in terms of, well, just bringing those issues to their attention? What's appropriate in the circumstances? That will depend on how long-term your relationship with them is, and how, perhaps even how important the business relationship that you have is to that other business entity. And when is also important, because it might be that you can't exercise leverage all the way through your relationship, but there will be pivotal times within your business relationship where maybe a contract's being renewed, or you're entering a new phase in your relationship where you'll be taking on additional responsibilities, and you want to set that off on a right footing with respect to human rights. What the UNGP say about leverage is that you should ideally be looking for ways to increase your leverage in the ways that we've just described. But there may come a point where actually there's nothing more you can do, but you're still aware that this human rights impact is occurring, and you don't want to be involved in that. So the UNGP say there may come a point after having tried to exercise your leverage where you'll have to terminate your relationship with them. And you'll come to a point where you say, actually, it's no longer appropriate for me to be working with this business or this government or whatever it is, because of the severity of the human rights impact and the failure of your leverage to actually improve the situation. So, armed with those concepts of responsibility leverage, I just want to come back to this idea of human rights due diligence, which is really central to the UNGP. It's very specific how it's set out in the UNGP, and it involves a number of steps which I've set out on the slide here. The first step is that you need to actually assess what impacts your business is having on human rights. And this task could be a huge task, could be a small task. It will really depend on the nature of your business. And the UNGP recognised that this could be because it could be an overwhelming task, it is appropriate for businesses to take a reasonable approach as to perhaps which parts of their business they look at first. So whether they look at the most high-risk sectors that they operate in, or the most high-risk jurisdictions that they operate in, to gain an understanding of first of those issues before moving on to other issues, because these issues can be incredibly complicated. Through this process of assessing what impacts you do have, you should be able to work out where the gaps are, and then move on to the stage of working out what your responsibility is for those impacts. And this comes back to what we were just talking about in relation to the 3 different types of responsibility. And that's really key to understanding what action you would take. So once you've established that you are contributing, then you'll know that the next step is that you need to take this action in order to stop contributing to that impact. And the UNGP are quite helpful in this respect as well, because they have some quite detailed provisions about how to again prioritise what action you should take. You should deal with the most severe impacts first. And I think the important point to make here is that due diligence as conceived in the UNGP is all about how severe is the impact. So it's different from due diligence in a normal corporate sense, where we're looking at how severe is the risk to the business. And we're flipping the lens and we're saying, how severe is the impact? If I've got a range of, if I've identified that I'm impacting right to life, right to water, labour issues, how do I begin to start tackling and deciding what to do in relation to those, and which ones do I deal with first? Now, I'm not trying to say that certain human rights rank above other human rights. That's certainly not the case, and that's not the message that we get from the UNGP. But what the UNGP are trying to do is to try and help companies take a practical approach to this. So they would say, well, in that situation, you take the impact to the right to life first, because that is the more severe. Once you've worked out what you're going to do about your human rights impacts, you have to, the UNGP say, you have to move on to a process of tracking those. And that's very important, the UNGP say, because they say unless you actually track what you're doing, you can't really measure it, and unless you measure what you're doing, you can't really manage it. And for most companies, this concept is bread and butter of the way that they operate in any case, and most companies will have KPI standards performance indicators with which they can judge their performance, and those sorts of processes need to be applied in this situation as well. Along with tracking performance, we also have the element of communication, and this is key to the UNGP's responsibility to respect. So this is the idea that you have to actually feed back the findings of your due diligence to those that have been affected. Now that could be the people in your business, that could be the employees, or that could be further afield, and the UNGP talk a lot about public reporting. Now this is a difficult area because, as we know, reporting can create risk in the ways that we've discussed already in terms of public perception. And the UNGP recognise that. They say, well, no, there are issues of confidentiality that are at play, which might mean that you can't report in all circumstances. But really what they're doing is they're setting a standard which says, start thinking about communicating, and by thinking about communicating, do so with the whole range of stakeholders, recognising that you're having impacts on the whole of society, not just on your employees. And then the last stage is remediation, which I won't go into much detail because we're going to cover that later today. But essentially this is the idea that if it's appropriate, then companies should have in place ways of remedying or mitigating before the problem occurs, the human rights impact. The important thing about human rights due diligence is that it's iterative, so it's not a one-off. It's not like an M&A transaction where you do due diligence and then you go ahead with a deal because you're happy with the risks as assessed. The nature of human rights is that they are evolving because they involve people, but also the nature of businesses is they're constantly evolving and doing different things and carrying out different activities. And at each stage where you're embarking on a new project or some transaction that could well have human rights impacts, the UNGP are really saying that you've got to rerun these due diligence processes to check what those impacts are so that you can deal with them. Now, all of what I've just described can be dealt with by what we would term a human rights impact assessment. I know some people have already asked about this, but it's important to recognise that the UNGP don't say it has to be a human rights impact assessment, and if it's not called a human rights impact assessment, it doesn't count. This kind of process where you're finding out what's going on in your business and finding out how your business impacts human rights is something that businesses do anyway and have been doing in relation to certain other risks, for example, environmental risks. And the UNGP is in favour of adopting and adapting existing processes rather than reinventing the wheel. I think that's important to recognise. It's not a case of just simply sort of parachuting in something called a human rights impact assessment and then it being appropriate. It will very much depend on each business as to what's appropriate to them and how they deal with these issues. So just briefly, I wanted to look at how companies have responded to the responsibility to respect in the last 5 years. We've seen a huge uptake in human rights policies. There's a website, the Business and Human Rights Resource Centre, I think that is misspelled on the slides, which has got over, I think, around 500 human rights policies which they've collated, and there are probably many more out there as well. We've seen standard setting, again, as we saw with states and multilaterals there, we've seen corporate organisations coming together and aligning their principles with the UN Guiding Principles. A notable example here is the Equator Principles, which applies in project financing, as well as some other contexts, which they reflect the IFC standards, and now they, as well as the IFC, also align with the UN Guiding Principles. We've seen a lot of movement within sectors as they begin to grapple with the UNGP and try to understand how this actually affects their specific industry. And the oil and gas industry has been at the forefront of this because typically a lot of these issues are issues they've already been having to grapple with since time began. So organisations like IPICA, who are an industry organisation specifically in the oil and gas industry, have issued guidance setting out for companies in a very practical way how the UNGP can be implemented in the business. And as Yasmin mentioned last night, other sectors such as law firms have also done similar work in trying to work out how the UNGP applied to their businesses. We've also seen a real sort of uptake in voluntary reporting and metrics around this area. So in terms of voluntary reporting, the two companies on the slide, Tullow Oil and Statoil, have both made voluntary disclosures in relation to payments to governments. And then we've also seen the corporate human rights benchmark, which is actually a really interesting development. It's really been promoted by the responsible investment industry, who are saying, well, look, this is all very well. We understand that we have a responsibility to respect when we invest, but how can we judge that? How can we tell whether a company that we want to invest in is actually meeting the relevant standards? Well, they're beginning to develop this benchmark, and I think there's a trial period at the moment. We'll see the first report in November, which will take 100 companies in 4 specific sectors, being agriculture, apparel, and extractives, and one other that I've forgotten. But essentially, the idea is that they will then rank those companies according to how well they've embodied the UNGP, or how well that they are respecting human rights. So I suppose the question at this point is, how successful have the UNGP been in driving better responsibility to respect in companies? And I would say that we're at a moment where a lot of groundwork has been done, and yet there's still probably a lot more to do. But what's quite notable is that there's been some surveys recently that talk about companies' attitudes towards the human rights. And the figures are quite striking. So 61% of those who were interviewed for a recent survey by The Economist say that human rights discussions have become far more prevalent in their organisations in the last 5 years. And I think that it's probably fair to say that there is a direct correlation between the UNGP and the rise in these discussions that's evidenced by these policy uptake and all the rest of it. Now, I just wanted to take a moment to talk about something that might not be immediately evident as to how it's applicable in this context, but bear with me. The UK Modern Slavery Act is, as I mentioned earlier, it's a reporting obligation. It was brought in 2015, and it applies to commercial organisations located anywhere in the world, both UK or elsewhere, who are doing business or part of their business in the UK and who have a global turnover of over £36 million. The Act requires all of those commercial organisations to make a statement setting out the steps that they've taken to ensure that human trafficking and slavery is not occurring in either their business or in their supply chains. Alternatively, they can make a statement that they've taken no steps. This statement needs to be signed by directors, so it's really at the top of, it's really in the sort of C-suite of issues that is, in terms of the issues, the importance of the issue that needs to be dealt with. That said, the statute doesn't really flesh out what needs to be put in this statement. It merely says that companies may wish to include information around what their business, how their business is organised, what kind of supply chains they have. It says that they should set out the policies that they might have in place to address slavery and human trafficking. It says that they should explain any due diligence processes they have in place, any mechanisms they have for measuring effectiveness, and any sort of training that they might be providing on issues of modern slavery. Now, the penalties are not very severe under the Modern Slavery Act, but what's really important about this is it's something that's really driven, I guess, by stakeholder interest and accountability. So essentially what we're seeing is NGOs who are focusing on companies and whether or not they've made these statements, and already, even though the Act has only very recently come into play, we're seeing companies being criticised for not producing statements, or they are criticised when they have not produced statements of sufficient detail, or where they've simply made a statement that no steps have been taken to address modern slavery. Now, what's interesting about this piece of legislation is actually, whilst I don't want to overstate this, a lot of companies have adopted a very proactive approach in relation to the statement, and they've actually been issuing statements that do detail what their due diligence processes are and what their policies are, etc. And what I just wanted to draw out was the fact that there's actually quite a lot of similarities between the kind of things that are suggested to be put in these publicly available reports and the UNGP. And certainly in the case of those companies that are producing very sophisticated statements, it's often the case that they already have a pre-existing approach to human rights generally that's respectful, and that even goes as far as implementing the UNGP in their businesses. And so therefore they are well placed to deal with this statement very quickly and effectively. So in this respect, I think this piece of legislation is quite an interesting one, because what it shows is, on the one hand, the state trying to create better standards in terms of business and human rights, but also business, on the other hand, responding quite positively to the reporting obligation. Now, it's going to take a while for this to bed in, and we'll have to see whether this is something that happens across the board, or whether it's just going to be a few leaders who take this opportunity to really embrace the reporting requirement as a way of dealing with human rights, both in respect to slavery but more generally. But it's an interesting piece of legislation, and as we'll see in the case study later, it's also a piece of legislation that's going to have very hard law impacts for any of the businesses that are operating in the supply chain of businesses that have to operate in the UK, or who have themselves got an obligation to report. Okay, last but not least, I'm just going to cover briefly the third pillar. And the reason I say briefly is not because it's not important, but because we're going to have a lecture later that will go into more depth on this issue. So the third pillar is often described as the forgotten pillar. I'd actually say, in a way, it's not forgotten, or rather, it's an area that needs to have a lot more focus on it. But actually, it's an area that is very regulated. It's a very regulated space. But the problem is that despite all the laws and things that we have in place, human rights are still being affected, severely affected, and victims are not getting remedy for that. Now, this is a fundamental human rights issue in itself, because under various international instruments, access to an effective remedy is in and of itself a human right. So the contribution of the UNGP in respect of the third pillar is to sort of map out two things. Firstly, they talk about what remedy actually looks like. I think there's an assumption that, especially from a corporate perspective, that remedy equals monetary compensation. But in fact, when we're talking about human rights abuses, we need to be thinking much wider than that. We need to be thinking about non-financial compensation. We need to be thinking about the role of apology to actually remedy a human rights abuse. We need to be thinking about restitution in a wider sense, in terms of rehabilitation of people who have been impacted adversely by human rights. There's a whole range of issues or ways in which we can mitigate human rights abuses. And the UNGP really sort of start to flesh that out and put that on the table. What they also do is they map out all the different types of grievance mechanisms that currently exist to provide access to remedy in these wide range of ways. And they are set out on the slide. So on the one hand, we'd have state-based mechanisms, which would typically include the sort of judicial mechanisms that we're most familiar with, i.e. the courts, but also include non-judicial mechanisms which are state-based. And the best example of this is in the OECD guidelines, where we have a dispute resolution mechanism where complaints can be brought when there are breaches of the guidelines for multinationals. And then on the other side, we have non-state-based mechanisms, which is really talking about operational level grievance mechanisms or community level grievance mechanisms, i.e. the measures that companies are taking on the ground to try and tackle problems as they arise, and hopefully before they actually become human rights abuses, and to try and mitigate those up front. Now, I'm not going to go into much detail about this, as I said, but I think it's just important to remember that there are actually a huge number of developments in this field, and in respect of state mechanisms, I think we all know, and I won't go through them now, but there are many access to barriers in respect of judicial mechanisms. So, typically those would fall into two categories. You have the fact that there's a lack of substantive actions. So how can you actually, what kind of causes of actions are available when human rights abuse occurs, given that corporations aren't actually legally responsible for human rights abuses? We have tort, and that can be used to a certain degree, but it perhaps doesn't go far enough. We also have many procedural barriers. So these are the issues around legal aid. How much does it cost to launch a claim? Is it realistic for victims to actually launch claims when it's going to take a lot of time and money, and really, in terms of the remedy that they're going to have in their hand at the end of the day, it can often be fruitless, because it really may well be way too late to actually do anything of any value. We could talk about those issues for a long time, but what I really wanted to say is that there are, at this point in time, really some very far-reaching developments at a sort of interstate level, coming from the Council of Europe, coming from the OHCHR, which are trying to shift this debate and trying to find different ways of making companies liable. Now, that's important for us to know, us as advisors to corporations, because the international movement is to try and reduce barriers by creating more possibilities to sue companies, and that's beginning to take shape. And I've listed a few details on the side. I don't think we've got time to go through them now, but I'm very happy to talk about those later on. So, for example, the draft bill in France, which is trying to establish a duty of care on parent companies, where they would be required, if the bill is successful, to carry out due diligence on their subsidiaries in relation to human rights risks, and if they fail to do so, then there will be civil law implications for that. So these are the kind of innovations, if you like, that are happening. Now, I've listed there on the slide a few of the non-state mechanisms, and I'm not going to go into those because those will be covered later. And that's basically what I wanted to say in terms of the UNGP and how they operate. I think I'm sensing I've gone over time, so we'll move on to the next section.